let's go back to the impact of Section 66A of the IT Act. You mentioned the fact that the police quite freely used that section for reasons that probably went beyond what was originally part of the motivation behind the section. I know that eventually a case was brought to the Supreme Court of India, Shreya Singhal versus Union of India, a big case that you were part of it, and that case really transformed, seemingly from the outside, it seemed that it transformed the relationship of the authority with social media and with the users of social media. So could you maybe tell us a little bit more about the case, the story, the fact behind the case, and what did the litigation bring about?
So Shreya Singhal is a law student, or at least she was a law student when she brought the case. So you can blame all the lawyers for good things as well as bad things. But as they say, there are no lawyer jokes, they're all true stories. But this one is a real good story, actually. So starting from 2011, we did see a lot of people using the media to criticize the government or just expressing things which they felt like. And I think in India, everybody seems to believe, or maybe it's in the world, that people have the right to be offended, but they do not want to give anyone else the right to offend. And the limits of free speech are set by cultures, with national laws, but especially in this case, we started seeing it's also set by who can capture the narrative and what their own sensibilities are and how much power they have in terms of with the authorities, in the government, or just amongst the hooligans. So we started seeing quite a lot of stuff, and I'm a lawyer, so of course we started getting a lot of cases, and we run a pro bono litigation practice which offers help to people who were bearing the brunt of all of this. So we started hearing those cases, but due to attorney-client privilege, we were not talking about them in public. But we knew that this section, because it was so vaguely termed and everything was so wide, that to a lot of us as lawyers, this was unconstitutional. And this was in complete violation of the right to free speech and expression, which is given by the Constitution of India. And we started having some discussions with the government officers that time about this, but they were very defensive about what they had written, which to my mind has also changed with internet. Policy making has now changed because whether you want to like multi-stakeholderism or multilateralism, it doesn't matter. People are already discussing all the issues out there in the chat world, and they are going to tell you what they think. You can ignore it to some extent, but it's only a matter of time before everyone comes together and tells you that this is what they want. And that's why the internet belongs to the people, and governments and companies can be trustees of that. So what started happening was that we started hearing these cases, but some of them caught national attention. Police is notoriously late, corrupt in India in many parts. It doesn't mean that the entire departments are bad. Some of them are great, but a lot of them at least are not swift enough in their actions, let's say. Sometimes you have to go to quite an ordeal to get a first information report registered, which is just a complaint. So, but police was very swift if ever somebody tweeted or said anything. So one of the biggest cases which came out in open was, there was a professor in West Bengal who had forwarded an email, a joke via an email about the chief minister of that state. And the supporters of the political party to which the chief minister belonged, they went and beat him up. And he was actually jailed for forwarding that email in which there was a joke around
on top
him.
of being beaten.
Yes. And his name is Professor Mahapatra. So there was an outpour of support for him. And people were like, what did you really do? Oh, I forwarded an email. I thought if he had to be punished, we could be punishing him for making a bad joke and just say, yeah, don't do that again. And you know how anybody would criticize people for a bad joke. But this is something which we'd not heard of. Then we heard that the finance minister at that time, his son, somebody said from the same district as his son, made a comment about the rise in the wealth of the finance minister's son. And somebody should look into it, and talking about corruption. And there was a lot of corruption in the prior government. That's the reason there was a change of the government. And at 5 a.m., police landed at this businessman's house to arrest him because he had tweeted a thing like that. And we did not understand what was the problem there. Yes, everybody talks about it all the time, and he's expressing what he thinks. If there's a rape, there's a murder, they take forever to come, but they're there at 5 a.m. in the morning to arrest, which was very, very alarming. And to activists and lawyers like us, when we were talking about a lot of these issues, all we were getting is, oh yeah, you guys create too much noise, you have a problem, there is no real issue, where is the data you are going to show us? And that time the law minister as well as the information technology minister was a lawyer himself. And I really had a big problem with him about how can you not see the ambiguity and in these words, in the vague terms which are being used. But we were told, oh, you create too much noise and problems. There's nothing wrong, and every country is doing it, and what are you talking about it? But what happened was there were two girls, 21-year-old, and the other probably was 20 years old. These two girls, they posted a Facebook status. A leader who from the big state of Maharashtra, where Bombay is, he passed away. And he was popular. He was also very well known for his divisive politics. And when he died, Bombay was shut down. The entire city came to a standstill. So the girl said, I don't understand why when a politician dies, a city has to stop. And why can't we just go about our business? And her friend likes that status. And then the supporters of the political party to which this leader belonged to, they came up. Her uncle was a doctor who had a clinic in a small area. They actually destroyed his clinic. There was a lot of vandalism out there. And these two girls were arrested. And they were arrested in the evening. And people were appalled at what had happened. So somebody puts up a Facebook status, and her friend likes it, and these two girls are arrested. There was a huge criticism about it. The chief minister then had to call, the girls had to get released, but it was only when the media caught wind of it, and then this happened. So we had all been discussing something about this for a long time. But as lawyers, you also have to decide about issues of who the petitioner will be, which court we will go to, and what's happening, if they're ready and not, or what not. And Shreya Singhal, to her credit, and her mother is also a lawyer, but she, as a law student, and I think a great thing, and everybody should feel indignant about it, she was like, okay, I've had it. I want to talk. And she says that she goes to her mother and says, what can we do about it? And at that time, another thing which had happened was that they were using Section 66A to get to people who were themselves using social media platforms to express their opinions. They, when I say they, it means the authorities. But there was another way for them to do something else. They were asking the platform companies, which is Google's, Facebook's, Instagram's, Twitter of the world, they were asking them to take down content which was showing that political party, or as we call the first family, the Gandhis in a bad light, or anyone else, or anything which was inconvenient for the politicians, or what they did not approve of or they did not like, was, oh, YouTube, we don't like this video, take this out. And there's another video talking about corruption, take that off. And Google has some links about talking about this particular leader, you have to take that down. And the companies, rightly so, were like, no, we're not going to do that. And of course, there is always, these issues are being developed, which is why when you asked me the first question, the norms and the legal concepts are shifting right now, and the shape shifting is so swift that everybody's catching their breath. So platform companies whose servers sit in California, but who have big markets in these countries, and who are also right now expanding, and their users think that the best thing about these platforms is their ability to say anything. They are also in the midst, because they only get more users if the users trust them. But if they start becoming the moral police, or they start actually restricting the free speech and expression, they lose business. But they also want to play the Lex Loci server game. I am not here. I am in California. You cannot tell me what to do. It sometimes works in our favor and sometimes it does not. Because if you're in a country where the law is more restrictive, you want to take advantage of First Amendment. But sometimes when you want something else, then you don't want them to play that game. But to be fair to in this situation, the platform companies were great about it. They refused to take down a lot of content, and they were under a lot of pressure. So the government in 2011, April of 2011, came up with something which we called Intermediary Liability Rules, the Information Technology Intermediary Liability Rules 2011, which were just like in the US. There is Section 230 of the Communications Decency Act, which says that Google cannot be held liable for user-generated content. So if X person who's a user on YouTube is putting something up, you cannot go and say, I'm taking Sergey to jail, or I'm going to now take Sundar Pichai to jail for that. Very simple concept. That's how internet can work, and works beautifully here. And that's how in India also we'd had a notorious case earlier in which something which was equivalent of an eBay, they had dragged the chief executive officer of eBay because a CD was being sold which had some pornographic material. And the entire industry had gone to the parliament, rightly so, and saying, you cannot have any e-commerce here if you're going to hold platforms liable for this. So there was an intermediary liability. There was no exemptions for these companies or platforms who are intermediaries or telecommunications. But the rules which they promulgated in 2011, they were to say, if you do not take down the content which we are asking you to take down, and those rules went beyond what the Constitutional allowed, then you will lose your exemption from liability. So I don't like X video, and Mishi posted X video. I will get her arrested under 66A, and I will go to Google and say, you take down that video, otherwise I'm going to drag you also to court and your executives to court and let you lose that exemption from liability as well. So they had everyone from all sides. It was a pretty neat thing if you think about it. And but for us, this was like the most appalling thing ever. And for me, when I started working on it in 2011, to me it was just right there, something on the wall. Everybody should be joining and be yelling and screaming. But nobody was doing that. And when Shreya Singhal filed this petition, we already had been doing a lot of work on this. We had worked with some members of the parliament who also saw the ridiculousness of this law. Some members of the parliament had worked on an annulment motion and to get rid of these rules, and some had called for that section to be declared unconstitutional. There was P. Rajiv, Baijant Panda, and a bunch of other members of parliament who had joined this, and Rajiv Chandrasekhar. And we'd been working with them, so we joined the petition. But I joined it as a lawyer on behalf of a review website, which is India's equivalent of Yelp. So the review website was now being told every time there was a negative review about anything that you have to take down that negative review, otherwise you will be dragged to jail. And very interestingly, unlike Yelp, where you can Yelp about the dish which you like or the restaurant you hate, India does not have a very, very strong consumer protection enforcement law. The law is there, but the systems take forever. So very interestingly, this website, people would review movies, restaurants, but they were also reviewing police stations. They were reviewing, educational institutions.
Okay.
So the Trump University kind of educational institutions are dime a dozen in India. Many of these, the middle class Indians, not only middle class, but almost all Indians, which is very, very peculiar and very interesting thing, they understand that upward social mobility will come through education.
Yeah.
And they really spend everything they have on their kids' education. So there were these middle class people who didn't have a lot of money, but they were spending and saving all their lives for $2,000, $5,000, $10,000, sending their kids to these institutions who were saying, we're going to give them business degrees or law degrees or engineering degrees, and then they were hoping for a better future. But then there was no real degree, or there was no job, or there was no teachers out there. And a lot of these students use this particular website to review those educational institutions to warn future students. And a lot of real estate developments were being reviewed. Now, real estate developments, educational institutions, all very rich people who started using the police and this law to harass the website and say, you have to clean up. Every negative review will have to take down. So when mouthshut.com, which is how it is called, when they came to us, they had seen me speaking about the issue on both intermediary liability and 66A, and they had been thinking about it. And when they came to me, and I was very interested because this was perfect as a lawyer, as an activist, and they were very interested. They were like, if I put a sanitized version of my website, who will visit my website? If all I have is positive reviews, then nobody's coming to my website. Now, how do I carry out my business? And this is a very cash positive, growing company, which has very big ambitions, of course, to integrate financial services, payments, e-commerce into it. And the CEO is a young guy who studied in New York, had gone back and done something big. And he said, I run this great business and I need to grow, and this is the great startup culture which India wants to encourage. Now you want me to shut down.
Yeah.
And so he wanted actually to challenge this. And this was very interesting because not only did he say that you were curbing my right to free speech and expression, but also the right of my users to receive information. Which is ingrained into right to free speech and expression. But there's another thing which the Constitution gives. The Constitution gives the right to carry out your business or profession without undue interference from the state. So he's like, now you are interfering with my right to carry on my business and profession. So it became very interesting. And by the time we were in court, there were 10 petitions, 80 plus lawyers on both sides working on a case, which started in April of it started in 2012. We filed in April 2013. The judgment came in March of 2015. And I think in the 50 years, it is one of the most landmark judgments on free speech and expression in India, where both the judges, they also expanded the doctrine a little. There's more First Amendment in there than it has ever been. And I love it. There's also Shakespeare in there.
So tell us, what exactly did the judge decide on Section 66A and on the intermediary liability rules?
66A was declared unconstitutional in its entirety. So there was no path of golden mean. There was no, let's have a little bit of it here, let's have a little bit of that. And the judge decided it was unconstitutional. This is not what the Constitution of India guarantees. And the terms were very vague. and there was no clarity about what the limits are, and the limits have been set under Article 19, Clause 2, which are the reasonable restrictions, and going beyond is not permissible under constitutional law.
Sure.
So the entire law went away from the books on intermediary liability, because there were parts of those rules which were just verbatim copy of 66A. They were also read down, as we say, just to, which probably in the US term is when they clarify and say this is not what they mean. So they read down that those rules. And most importantly, intermediary liability, they said that you will have to get a court order if you want some content to be taken down. Because earlier, XYZ could just write and say, take down this content. And you had to take it down, otherwise you lose your exemption from liability. But now the Supreme Court said you will have to follow it up with a court order, and then only you can request for some content to be taken down. So now it also means that it will only be somebody who's very seriously affected, and that's the affected person, and who will go to the court, and then and who knows that's a requirement, then only will make a complaint. And 2 or B was that it would be subject to judicial scrutiny.
Yeah.
It's not that any random person who decides to clean up whatever they don't like online about them or about their institution can just tell the other person, yeah, you have to do this. I think those were 2 very important things.
How does the insistence on court order compare to the rest of the world that has adopted a notice and take down approach?
So in the Copyright Act,
of the United States?
No, in India.
In
India, in here it is the Section 512 of the Digital Millennium Copyright Act, and you're rightly pointing out about that. But in India Copyright Act, this system was already there.
Okay.
They said that if there's a copyright infringement, then you can write it down to the platform or the company, and they will take it down, but within 21 days you will have to follow it with a court order. All we were saying is, you've already done it in copyright, why don't you do it for others?
Sure.
And yes, we had held a lot of discussions and consultations as under the umbrella of my nonprofit, to just ask people, what were the Canadians doing? They have a notice and notice system. What are the Americans doing, which is Section 230, that complete exemption, and the DMCA bit? And what are the Europeans thinking of this? What does the Netherlands think of it? So we've done quite a bit of studying about it, and we had come up with a report which was submitted by one of the petitioners to the Supreme Court to tell them how it compared to the rest of the world also. But yes, there are different ways, different things people are looking at. To my mind, judicial scrutiny is the right way to go, because otherwise there is this expectation and requirements from the companies to solve every problem.
Sure.
And for them to be the torch bearers of free speech and expression, and also the responsibility. Not that I say that things are not changing, because earlier there was public broadcast, which was subject to different rules, whether in this country or in other jurisdictions. And there were newspapers which were private or national, but those were subject to very different rules. And now when private platforms are the ones which become or replace the chatter at the water cooler or everywhere else in the world, then what are the new norms we're all discovering? But at least as of now, it's not that any random person can write and do this. I personally still like the 230s exemption from liability. Full here, exemption. Communication Decency Act. And 512 is effective because of, there are problems with it. But this also shows you how...
But even in the United States, there is some notice and takedown system with other materials, not copyrights, but anything else, basically.
Yeah, terms of service, which is now becoming an entirely different area altogether. Many of us forget that Facebook is a private company, and so is Google, Twitter, LinkedIn, or whoever buys whoever. And they are way more answerable to their own shareholders and Wall Street than they're answerable to their users, although they're interconnected. But these companies do whatever their terms of services say. And terms of services many a times are much more restrictive than the constitutional rights are.
Yeah.
But they are under no obligation to make them actually different than what they are. And so, yes, you can write to one of these companies based on their terms of service, or they would be happy to tell you whether it falls under that or not. I think all over the world there is some consensus that child pornography, terrorism-related activities, which are also now becoming, again, blurry because of, it's like ISIS without guns is only a blog, is what Trevor Noah was saying. So I think there is something serious behind that also. So those are blurry lines, but still, child pornography, terrorism, these are certain things which nobody disputes must be taken down. It's very interesting that Hollywood has succeeded to make everyone see copyright as seriously as perhaps child pornography and terrorism. And everyone else isn't just making noise. But that also tells you how powerful that lobby of MPAA is. And that's why a lot of times there's a disconnect between copyright and other forms of free speech.
Yes.
And I do think that it is now the time to have those discussions. Actually, it was the time at 2000 when Grokster, Napster started. But now more and more, it's highlighted how copyright is being used to restrict speech and how terms of service are being used. But we're in changing scenarios right now.
Okay.